An announcement before we get started, I'm pleased to announce Phillies and Giants, first pitch 4:19 local time in San Francisco. So we will adjourn prior to that.
You can tell he's from Philadelphia.
They do it in parts for the second game, later games.
Ladies and gentlemen, I'm pleased to call to order the meeting of the State Ethics Commission on this 19th day of October 2010, meeting in New York County, New York County Administrative Center, 2080 Market Street, North Pennsylvania. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to the said executive session or at the next meeting thereafter. Executive teleconference meeting was held on July 8, 2010 and September 17, 2010, and the executive quasi-judicial deliberation meeting was held on June 22, 2010, and the executive meeting will be held immediately following the October 16, 2010 public meeting to review matters that are by statute confidential, and I think that was meeting October 19, not 16. Pursuant to the Public Official and Employees Ethics Law, Act 170 of 1978 is amended, Act 9 of 1989, June 26, 1989, as amended by Act 93 of 1998. The State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg to specifically seek input from the persons and organizations who represent any individual subject to the provisions of this Act and from any other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive input or testimony of the said individuals pursuant to the provisions of the law. As our previously published notice has indicated, the Commission will request copies of any statement that is to be presented. The individuals presenting the statement before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. And with those formal notices, we'll move on directly to the agenda. First item of business is the approval of the June 22nd, 2010 public meeting minutes. Those minutes have been distributed to all commissioners. I ask, is there a motion for approval of the minutes?
So moved.
And it's been moved. Is there a second?
Second.
The floor is open. If there are any additions, corrections, suggestions to those minutes? Hearing none, they will be approved as distributed upon the vote, all saying aye.
Aye.
And negative-minded, there being none. Moving on to the civil penalty orders of default on the agenda, Commissioner Falk, I think you reviewed those for us.
I do, Mr. Chairman. There are 7 civil penalty default cases that are now before this commission for decision. These cases involve respondents Rudolph Hammond, Diane Maynard, Patrick Dyer, Sherman Gottschalk, Alex Dombrowski, Lynn Giles, and James Allen Marchewska. Respondent Hammond, who failed to file one statement of financial interests, filed a delinquent form with this commission and submitted a check in the amount of $100 to this commission, payable to the Commonwealth of Pennsylvania in response to an offer by the investigative division of the commission to enter into a consent agreement. But he did not return a signed consent agreement to the investigative division. Respondent Giles, who failed to file 2 statements of financial interest, filed the delinquent forms with this commission after civil penalty proceedings were initiated against her, but she did not file an answer or otherwise respond to the civil penalty proceedings. The 5 other respondents did not file timely answers or respond to the civil penalty proceedings. Following review, it is my opinion that as to the respondent Hammond, the Commission should levy a civil penalty of $100 for the delinquent statement of financial interests. As to each of the remaining 6 respondents, the Commission should levy a maximum civil penalty of $250 for each delinquent or deficient statement of financial interest. For respondents Maynard, Dyer, and Dombrowski, the total civil penalty liability would be $250. As to respondent Giles, the total civil penalty liability would be $500. For respondent Marchewska, who failed to file 3 statements of financial interest, the total civil penalty would be $750. As to respondent Gottschalk, who filed 4 who filed 4 deficient statements of financial interests, the total civil penalty would be $1,000. It is my opinion that the Commission should also order respondents Maynard, Dyer, Gottschalk, Dombrowski, and Marchewska to file or amend their statements of financial interests. There is nothing of record that would constitute a defense or excuse for their non-compliance. Based upon my analysis and comments, I would like to make the following motion that they be penalized as I have reviewed. And I move that this Commission levy civil penalties against the following respondents, totaling the following amounts for failing to file statements of financial interest or for filing deficient statements of financial interest for the respective calendar years as required by the Ethics Act and the regulations of this Commission. Number 1, Rudolph Hammond, $100 for calendar year 2008. Number 2, Diane Maynard, $250 for calendar year 2008. Patrick Dyer, $250 for calendar year 2008. Sherman Gottschalk, $1,000 for calendar years 2005, 2006, 2007, and 2008. Alex Dombrowski, $250 for calendar year 2007. Lynn Giles, $500 for calendar years 2007 and 2008. And James Allen Marchewska, $750 for calendar years 2006, 2007, and 2008. Further respondents Maynard, Dyer, Gottschalk, Dombrowski, and Marchewska shall be ordered to file or amend their statements of financial interest for the years stated within 30 days of issuance of Commissioner's orders.
Thank you. With that motion, is there a second to the motion?
Second.
The motion has been moved and seconded, but I ask, is there any request of the Commissioner that any of these should be handled individually rather than one motion encompassing all of those? Seeing,
Question.
yes.
The difference is just the number of years, because one's 1,000, one's 250.
With that, I take it there is no request for individual consideration, so we will move on the motion encompassing all of those in the motion. Any discussion, suggestions, questions? There being none, all in favor, kindly respond by saying aye.
Aye.
Are there any opposed? There being none, that carries. I should also note for the record, and Ms. Hertzberger, I'm sure you know that the Commission is in full attendance. Every Commissioner is here and present. With that, moving to the civil penalty reconsideration, Commissioner Volk, I think you have addressed that one as well.
Yes, I have, Mr. Chairman. I've reviewed that thoroughly. Based on what has been presented, I find that the request does not meet the conditions for reconsideration, and I recommend that it be denied.
There is a motion. Is there a second to that motion?
Second.
And there is a second. Any consideration for discussion? Comments, questions? There being none, all those in favor of the motion kindly respond by saying aye.
Aye.
Are there any negative-minded? And hearing and seeing none, the motion is carried. Moving on to the next item on the agenda is consideration, really, of the stilt matter, and we have all received a great deal of information about that in written form. It's been discussed at previous meetings. For the purpose of the record, Ms. Hitty, I would ask you just to give us a brief review on the question presented before us.
Thank you, Mr. Chair. The stilt matter, as the Commissioners will recall, involved a challenge, a constitutional challenge to the confidentiality provisions of the Ethics Act that prohibit a complainant from discussing the fact that a complaint has been filed with the State Ethics Commission. The matter was filed in the federal courts. The Commission, as well as the Office of Attorney General and the Executive Director, were named defendants. At this point, it's simply our Executive Director and the Attorney General who remain defendants in the matter. Both the Middle District and the Third Circuit Court of Appeals have ruled against the Commission's position defending the confidentiality requirement. So at this point, the Commission simply has to decide whether it's the Commission's view that the matter should proceed further.